Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about getting out of debt through Chapter 7 Bankruptcy. Joining me is Jesse Barrientos, my co-host. Jesse, how are you, sir?
Really good, Dave. How about yourself?
I'm doing well, Jesse. We're going to dive right into Chapter 7. It's Fresh Start Bankruptcy. It's under the U.S. Bankruptcy Code. It's the most common chapter that people do file for bankruptcy, and it's relief.
Well, what is Fresh Start? What exactly is the idea behind that?
Well, the idea is the government didn't want you to be strapped with burdensome debt for your lifetime. So once every 8 years, if you qualify, in other words, if you have income under a certain amount and you don't have extensive assets, you're able to wipe the slate clean for a lot of debts, but not all debts. Student loans, recent taxes, parking tickets, child support, alimony, maintenance payments, those debts survive, but the overwhelming majority of miscellaneous debt is wiped out and the person is afforded a fresh start.
So I can get back on my feet and I can become a nice, productive, contributing member of the society to boost up the economy.
That's right. You can start buying things again. You can start contributing towards society, be a better father, a better husband, a better son, a better church member. You get a new lease on life financially, so you're not carrying this weight all around. And you know, it's factored into all the prices of everything we buy, so it is something that is provided under the law. Merchants have a factor in for it, so it really gives you a nice fresh start for someone who needs help.
So it's sort of like that when you factor in the price of the products that you buy in the store, there's a little bit of extra to count for some of that stuff being stolen for shoplifting and that kind of thing.
Exactly. Yeah, it's all factored in.
So we're all paying for it is what you're telling me.
We're all paying for it, but think of it this way. You're paying a little extra, but you don't have the burden of debt. You're able to afford your groceries. Whatever you charge, you're able to pay off. You're making your car payment, you have a roof over your head. So you have an advantage. You're doing well. For those who are not doing so well, the government says you don't have to be burdened with debt if you otherwise qualify. So if you're making money, you're not going to be able to file a Chapter 7. If you have a lot of assets, you're not going to be able to game the system and file for bankruptcy. But if you're struggling, if you're hardly making ends meet and you're carrying a ton of debt, the government, the federal government, provides this as a remedy. And it goes all the way back to biblical times, as you might want to talk about. This theory of bankruptcy and giving people a fresh start. Talk a little bit about that, would you?
Well, I don't know. When you look in the Old Testament, you see that they had the year of Jubilee, which was a time when all of the debts would be forgiven, when property would be given back, property that was just given to somebody for collateral. Any time that you would do something. In fact, I believe it also talks about directing people not to lend to somebody when they're close to the year of Jubilee, thinking that, okay, well, wait a minute, Dave, I'm not gonna lend to you because the year of Jubilee is right around the corner and I'm not gonna get it back. Yeah. So there's not going to be time for you to pay. So it does go back, although it's interesting to note, I don't think there is ever a time or evidence in the Bible or the Old Testament that there was actually a year of Jubilee when things were given back and slaves were set free and all that
But
stuff.
There's other references in the Bible to where you, as the owner of the debt, are to relieve that debtor, I believe, after 7 years. So you wipe the slate clean. So the theory goes way back. The actual term bankruptcy is thought to come from bancaroto, which means broken table. That's when merchants came out and sold their wares at a flea market type of setting. And if the merchant wasn't able to pay for the goods that he was selling, they came and they broke his table so he couldn't sell. So that's the theory behind it. But bottom line is, it's available. It's available for individuals. It's available for businesses. It's just the kind of country we live in. It's a very liberal law. It's a very helpful law. But of course, there are qualifications. There are hoops that one must jump through. It doesn't apply to everybody. But Chapter 7 is the most common chapter of bankruptcy.
Do you see a big influx? I mean, in this time of economy, when we have so many difficult things going on, and it's just a little blurb on the news just today about the housing market being the worst it's been in such a long time. Took a 25% or something like that plunge in terms of home sales and that kind of thing. You see a big influx of the Chapter 7s coming into your office?
I see an uptick in Chapter 7s, and there's a number of factors. Obviously, housing is a key. The fact that people are becoming unemployed in greater frequency, jobs are leaving this country, people can't hire, so therefore people can't afford to buy things, people can't afford to live in the house. The values of their retirement accounts have dropped incredibly, so there's a lot of pressure, there's a lot of strain, there's a struggle going on, and all the while this is happening, and by the way, there's no interest being paid in the bank accounts. At the same time, the credit merchants are charging 29.9% interest or more. Payday loans are charging 100, 200, 300% interest.
It's almost like usury. I thought we had laws against usury, Dave.
Yeah, we used to, but not anymore. Payday loans are legal. You're signing a form, and it's in pretty big print what that interest rate is. But unfortunately, people who need the money are going to pay whatever they have to pay. But the point is, there's so much stress out there that people can't afford their existing obligations.
So do you find that it is, and we could talk about, there's a whole bunch of different reasons people are almost infinite in terms of getting into a bad financial situation, but do you find it's because people have lost their job or something, and now what they're doing is they're using their credit cards in order just to basically survive, to be able to feed their family, to be able to provide a roof over their head?
I do see that. 61% of Americans are living paycheck to paycheck. There's another whole group of Americans that are surviving by making minimum payments, or maybe a little bit more, on their credit cards, but they're carrying a balance. Well, what happens is the minute you become ill, possibly a divorce or job loss, now you no longer can make that minimum payment, and that's when the late fees kick in, and the over-limit fees and the high interest kicks in, and it happens on a number of cards. So all of a sudden, someone who was able to juggle, and they come into my office all the time and tell me they've never been late, they got perfect credit. Yeah, but you're carrying $90,000 worth of credit card debt. So you're one major incident away from not being able to pay your bills, and that's what happens. So it creeps up on people, Jesse.
Didn't the new law just kick in where the credit card companies now cannot charge, they have to charge a specific fee for late payments and all those kind of things?
Yes, but what's happening is they're finding other ways to make money. So you're gonna see annual fees for some credit cards.
They're just going to shift the column.
Yeah, whatever the law of unintended consequences, whatever the government tries to do and pass laws, the credit card companies are going to find a way to adopt those laws, but also institute some new fees that are legal that they can do. For example, annual fees. Cutting some of the benefits on the cards. Sure. You're not going to be able to mandate from Congress what these private companies are able to do.
Dave, tell the folks at home what happens, because again, as you pointed out, a lot of people are robbing Peter to pay Paul. They're making minimum, or you say sometimes even a little bit above minimum. Hey, that's better than just the minimum. What happens if you just simply pay the minimum? Let's make it easy. Let's say $1,000 on my credit card, and I just make the minimum payments. Actually, a lot of times I think you'll see, initially, they'll tell you, hey, there's no minimum payment this month. If you're at a lower kind of balance like that. What happens if all I did, just that $1,000, didn't charge any more, I just made the minimum payment? What's going to happen to me?
Well, depending on what the interest rate is on the card, it's going to take anywhere from 5 to 15 years, depending on your balance, to pay off the debt.
So what is that $1,000 going to cost me?
Well, again, it depends on the case, depends on the interest rate, and I would have to do a calculation. I couldn't tell you off the top of my head because you didn't prepare me with the numbers. But what I will tell you is you're going to wind up paying an exorbitant amount in interest and or fees compared to the amount that you took out originally. So it's really something that the credit card companies want you to do. They want you to make the minimum. They want you to stay in this debt servicing trap where you kind of feel like you're doing okay, you've got good credit, you're making your payments, but in reality, you're making the credit card companies rich.
So we have talked and touched a little bit about why people get in that kind of situation, because they just simply don't make enough money, or it could be an illness you mentioned, or it could be a divorce or some other situation. It could even be some situation with your house. You're doing okay, you've got a little bit in the bank. Oh no, the whole boiler system and heater and all that just went out. So we need to be able to do that, or a new roof has to go on.
Yeah.
And so now I'm behind.
Most people don't have any kind of savings an emergency savings account. So therefore, when something happens, whether it be a car payment or a car breakdown of some sort or some kind of housing issue, there really isn't anything to tap into other than maybe a credit card advance, maybe a loan against the 401k if someone's lucky enough to have a retirement account that has any value. So it's really easy to fall behind. And again, 61% of Americans are living paycheck to paycheck. So you're just one job, 1 week layoff away from not being able to make your obligations.
Well, what about abuses of the system? We talked about it being a fresh start. So, hey, let's suppose, I've seen that big screen television down there at one of these big places here, and it looked really nice. Actually, I have one, but you know what? It's not one of these new 3D ones, Dave, and I know I'm kind of behind here, and I think that I'm probably going to be a candidate for doing a bankruptcy because, like you said, I'm just a paycheck away from not being able to pay anything off. So, hey, I determined that, you know what, I'm probably going to have to do this, but hey, I'm going to do bankruptcy. So, you know what? I'm going to rob the piggy bank here. I'm going to go down to the store and I'm going to buy this brand new flat screen 3D television and some accessories too, because I really want theater surround sound.
Right. Well, there's abuse and then there's living above their means. And in the case you're pointing out with abuse, that's when someone knows they're going to be filing, and within a 2 to 3 month period, they run up the credit cards, known as charge up, where they have a little bit of a credit balance left, so they quickly run out and charge it up so it's maxed out, thinking if you're going to go down, you might as well go down for the whole amount. Well, it's a mistake because the credit card companies know that, their attorneys know that, and the court knows that, and the bankruptcy code speaks of these kind of charges as being presumed to be fraudulent. And what will happen is you'll still get your bankruptcy. You'll eliminate most of your debt, but anything you did too close to filing can be held due and owing. So you really didn't get a full fresh start, did you? Because you still owe on these recent charges. So it's something we advise against. We don't like to see, and we don't even see a lot of it, to be honest with you, but it is in the code and it is prohibited.
Well, what kind of things, let's say, for example, somebody with a house, because I think there's a lot of misconception out there that people think that if they own a home, that they're not going to be able to get their fresh start. They're not going to be able to do a Chapter 7 because I own this home. Obviously, there's some equity in it here, and if I have equity, it can certainly be used to pay creditors. So I'm feeling like and believing, because that kind of might make a little bit of sense, that I'm strapped down here, and the creditors can attach my house now.
Right. Well, although bankruptcy is federal law, Illinois law dovetails in there a little bit in terms of what property you can keep free and clear from your creditors while you file a bankruptcy. One of those items is real estate, where you live, your house. You can protect as an individual up to $15,000 worth of equity in your property. So in the case of a married couple, you can protect $30,000 worth of equity. And equity is the ownership portion, the market value minus what you owe. Whatever is left, that is your equity. So you take the $15,000 or $30,000 exemption off of that as well, and oftentimes there's nothing left for creditors. You can file with a house with some equity.
So I could still have that if I have the $30,000. If there's two, and we have $30,000 exemption, so I can have up to that. Now, is it right there that close to the line? I mean, what if I have $45,000 in equity?
Well, depending on the value of your house, you can have more than $30,000 because the trustee, that's the person who oversees your bankruptcy case and takes a look to see if there's any assets that can be administered. That trustee would have to sell the house. You'd have a 5 or 6% broker's commission. So on a $200,000 or $300,000 house, that's $12,000 to $18,000. You also have some capital gains tax and also other costs of sale. So really, you can have more than just the statutory amount, but you don't want to be too excessive. Otherwise, the trustee might say, hey, it's worth liquidating this property.
How do we determine what the market value is?
Well, a couple different ways. You can go to a realtor and get what's known as a comparative market analysis. There's websites out there, Zillow.com, Zillow.com. Type in your address. That'll give you a good idea of what the house is generally worth, as well as houses in your area. So Zillow.com is a good source for people to go to.
So that really is what a market analysis is, whether or not you do one of those things or get an appraiser or a realtor or look it up yourself. Basically, you're seeking to look at other properties within about a mile and a half radius that is the same square footage, the same style. It also looks at other properties that are similar that have sold in the recent time.
Right. I've been practicing for 19 years, Jesse, and in the first 15 or so, we worried about real estate a lot because it was appreciating every year, 5, 6, 7%.
Exactly.
So trustees were, if anything was a close call, the longer they looked at it, it went up in value. Okay. Nowadays, in the last 5 years or so, real estate is not something the trustees want to even touch unless it's overwhelmingly available equity. Because look, we just talked about house sales down 27% this month. Even if there's equity, the trustee still has to list it, put it on the market, and hope to find a buyer.
And if they don't, it's just going to sit there and it's just wasted idle time.
Right. If it doesn't sell, it'll eventually revert back to the individual, to the debtor. But really, a trustee doesn't want to go through the steps unless there's going to be a payoff, because the trustee, I don't know if you know this or not, is paid on commission for what's administered, and it's a sliding scale. So the trustee actually has an incentive to administer an asset for the benefit of creditors.
Well, what happens if you have a situation where you have too much equity in the house and the house does get sold? What happens to my $30,000 that we're talking about here?
Well, you will get, as the homeowner, you will get a check out of the closing for your proceeds, whether it be the 15 or in a joint case, 30,000 equity, and that's your walkaway money. But really, a good bankruptcy attorney is not going to have you file a Chapter 7 with equity. And if they do, it's going to be with the understanding that the property is going to be taken and you're going to get a check when it sells. And that's called a potential asset acknowledgement. So you know going in you're going to lose the property. We don't see a lot of that. People who are going to lose the property either elect for another chapter or don't file a bankruptcy at all.
Let's talk about it, because it's very important with the situation, especially with the homes and everything else, with doing it, being able to get the fresh start when I own real estate. Now, let's say that I'm not caught up on my house. Yeah, I have some equity in the house. I'm within the limit that we were just talking about. I might have a little bit more between my wife and I, but I'm behind a few payments.
A few payments?
Right.
Okay. Well, in that case, you can still do a Chapter 7 because it's going to eliminate your miscellaneous debt. You're still going to have your mortgage debt because that's a secured item. If you want to keep that house, you have to continue to make the first and second or third, whatever mortgages there are on it. But here's the deal. If you don't have the other debt, if you've eliminated that in the Chapter 7, you might be able to either catch up on your own, you might be able to work out some kind of loss mitigation with them, or come up with some other kind of payment plan, because they don't want your house back. They've got enough houses on the market called REO homes, real estate owned homes. They're doing whatever they can for people who can actually afford it to stay in their home, because they don't want the home, Jesse. They want the payment under the loan. So 3 payments behind, not a bad situation, not fatal.
So if I do, and I do file, I mean, is there a potential that I could lose it?
Well, there's always a potential you could lose it.
When you're in that situation that your payment's behind.
Yeah, if you don't make the payments and you can't work anything out with the mortgage company, eventually they're going to turn it over to their lawyers. Usually after 3 to 4 months behind, they're going to turn it over to their lawyers and begin to foreclose. And that's a long process here in Illinois.
So, but if I have a bankruptcy going, that's going to stop it, isn't it?
It'll put up a roadblock temporarily, but what they'll do is come into bankruptcy court and ask for permission to proceed. That's a motion to modify the automatic stay, which is routinely granted in Chapter 7 cases for mortgage companies and auto companies. So it'll buy a little bit of time, but in reality, you're either going to have to get caught up, you have to work something out, or you might want to avail yourself of some of the other chapters that allow you to pay that amount back over time.
So in a Chapter 7 setting is, if I don't owe anything and I'm within the equity limits, I'm good to go. I can file it. What about now my income level? Let's say for a family of 2, just some with no kids, husband and a wife, I'm making $47,000.
Okay. Well, there are statutory limits that you have to be under to automatically qualify under the new laws for bankruptcy. For one individual, I believe it's $46,000. So you and your wife would be higher, considerably higher, a little bit.
Even if she's not working?
Even if she's not working, they look at the total household size. So that includes children too. If you had multiple children in the house, that would increase the amount of money that
That's
you can
why I'm
make
broke.
And still file. Now, if you're over these limits, you're still not kicked out of Chapter 7 yet. You have to submit to a means test, which is a mathematical formula based on IRS regulations for things like housing, clothing, transportation, food, to see if, in fact, you have the ability to repay your debts over time. And if it's determined that you do, then you fail the means test and you should really do a Chapter 13. But if you pass the means test, even if you're over the median for income, you'll still qualify under Chapter 7, and your case will proceed accordingly.
So, I mean, is that to prevent people from, for example, I mean, what's the thought, what's the intention behind that? Does that mean that, okay, if I'm making $200,000 a year, I'm in all this kind of debt? Before, under the old law, I could have gotten discharged, couldn't I?
Yeah. Well, there were certain ramifications that the court could look at to see if your budget was out of line and whether you had the ability to pay. But this is more of an anti-abuse provision, which basically analyzes someone's income and expenses a lot more closely to determine whether or not they have the ability to repay or not. And it's a strict formula. I mean, there's certain parameters in terms of what you can plug in for expenses and things like that and what you make, extracurricular, things like that, charity. But for the most part, it's a strict formula. So if it's showing abuse, the U.S. Trustee's Office in this district are going to bring a motion to dismiss your Chapter 7. So you want to make sure, again, that you have a qualified attorney who handles Chapter 7, who knows how to negotiate the means test, and basically advise you as to whether or not you're going to have a smooth case or whether you're going to run into problems or not with the United States trustees.
So now after this this time here, we're sitting here, we've gone through some information about the house and the equity, and I'm not behind and everything. I'm within the limits of the amount of money that I'm making, so everything looks good so far. Right? Is there anything else I have to look out for now that might prevent me from being able to avail myself of the Chapter 7 laws?
Well, there's pre-bankruptcy requirements that you need to fulfill. You need to submit to a credit counseling session.
A credit counseling session. Well, what's that? What's that all about?
Well, it's a 1-hour session or so with a credit counselor who will go over your budget, look at your income expenses, look at your debts, lay out some possible alternatives to bankruptcy for you. And when you complete that session, you receive a certificate, which is good for 180 days.
So 6 months?
6 months, and then you can file a bankruptcy. That's the first requirement. Number 2, you must have filed your most recent federal tax return or have an extension.
What happens if I didn't make enough to file a tax return, so I wasn't required to do it?
Then we would do an affidavit or a statement attesting to that fact. And lastly, the third thing you need is 6 months of paycheck stubs, reduced down to 60 days. We need the full 6 months to determine whether you qualify, but the trustees in the court require 60 days worth of paycheck stubs to make sure that what you put in your petition matches what you really make.
So is that preceding the actual filing then, 6 months?
Yes, it's an anti-fraud provision. So yeah, you want to make sure that you qualify, because if you're making a lot of money within the 6-month period, you may not qualify.
Well, wait a minute. Hang on. Listen here. Some guy got fired at work here because they got into a fight on the line, and now I've got a whole bunch of overtime, but I don't get that all the time. What are you telling me? I'm being punished because I'm working hard, I'm trying to provide for my family, and just because I got a little bit of overtime these last couple of months, it's going to jeopardize me and probably it might affect my ability to file a check. You're kidding me.
No, it might. If there's overtime all the time, you've got a problem with qualifying under Chapter 7. If you have overtime some of the time, then you might just have to time the filing, because you're right. You're not receiving overtime all the time, so why should you be punished? Well, you might have to wait out a statutory period to get you under a certain level, and that's known as the current monthly income. That's the average that you made in the last 6 months, and that's what the court looks at. What it's trying to prevent, Jesse, is someone who's making $150,000 a year, loses their job, immediately runs to file the minute they're unemployed, knowing they're going to get another job in that same bracket because of their educational background or expertise. So it's trying to prevent fraud. That's the whole point of this current monthly income average of the last 6 months.
Okay, so we've looked at that in terms of checking that out. There is, though, after I've taken my credit counseling class here for an hour, and we can take that together, right? If my wife and I are filing, you could do joint filings, correct?
Yes, husband and wife can file jointly. They can take the credit counseling together. That's correct.
But if you don't file jointly, because sometimes, maybe your wife hasn't taken your name, the credit is, or the debt is just in one person's name, do we have to take into consideration her income and her property and her debt as well?
Yes, a spouse's income, a non-filing spouse in this case, that person's income is a factor because the court looks at the total household income and the total household budget. So it used to be, before the law changed, if you married a very wealthy woman and you had debt.
There's a thought.
You look at that smile. That's $1 million smile. You would be able to file. Where nowadays they say, you know what? Your spouse is a breadwinner. She can help you pay these debts off over time, even though she didn't incur them. For better or worse, she married you. Now it's the worst for her because she's got to help you out. So it's the total family budget. So it is a factor.
What if one of my children are working? Does that get factored into it too?
No. Minor children, no. But spouse would be. Now, there are certain situations where a spouse's income is not considered, and that's where the parties are separated. And
legitimately separated.
Legitimately maintaining two separate households. That's a situation where the court only looks towards the one person's income, the person who's filing.
To be able to do that. So that's very interesting, very, very thorough as well. Now, after we've done this, but before I can get my discharge from the trustee, isn't there one more credit counseling, debt management class I got to take?
You need to take a 2-hour financial management class.
And as I understand it, Dave, you are one of the only attorneys that I'm aware of who is approved to teach that course.
Yes, I am an accredited financial counselor, and I have been approved to teach the 2-hour financial management class. And what it does is it really sets the individual up for future so that they don't fall back into debt. Smart decisions, Jesse, concerning insurance, health, major purchases, budgeting, very important. It teaches people to write down what they spend and do an allocation and actually see where they're at each month. So the 2-hour class is actually helpful, and most people do seem to enjoy it.
Well, that's really impressive, Dave. So you can help them out and get somebody a fresh start. And then, as kind of part of that whole situation, you are responsible for helping them being able to steer out of the financial disaster in the future if they apply the principles that you teach.
Yeah, and that's what I love about bankruptcy law, because you're actually seeing somebody come to your office when they have the weight of the world on their shoulders, so much stress, so much anxiety, and you actually provide a service which helps them. And then you give them good tips and advice so that they never fall into debt, hopefully, in the future. It's very rewarding, and that's why I chose that area of law as opposed to other forms where really clients aren't satisfied, because it's litigation, there's compromise, there's give and take, no one's ever pleased. So that's why I really enjoy bankruptcy law, Jesse.
Oh boy, I wish we had a whole lot more time left. I mean, it just seems like there's tons and tons of stuff, and that's why sometimes, we do several shows on that topic, because people aren't necessarily informed. They have the wrong ideas about the bankruptcy laws, and it's important for them to be able to, hey, first, be aware of it, and secondly, go to a competent attorney.
Right, definitely go to someone who practices bankruptcy all the time. And if you want to get a question to us, Jesse, what our listeners can do is they can go to legalactiontv.com, or they can email us at questions@legalactiontv.com, and we'll try and read some of those questions on the air. Again, that's legalactiontv.com or questions@legalactiontv.com, and we'll be able to get their question on the air. Either you'll answer it, I'll answer it, or if we don't know the answer, we'll research it, we'll find out for them. Because we want to not only entertain, but we want to give good information. And there's a lot of unknown questions out there in different areas of the law. So it doesn't have to be bankruptcy, it doesn't have to be divorce. We recently talked about orders of protection.
Talked about real estate, talked about filing a lawsuit.
We've covered over the last 3 or 4 years a multitude of topics, going back from DUI, personal injury, small claims.
We had some officers too, and
a
couple of judges here too.
Yes, and we're going to have some more of that as well. So that's it. We'll see you next time on Legal Action. Thanks for joining us. We've talked about Chapter 7 bankruptcy law. Take care.